all the titles that everybody's talking about, like driver's license and all that's all an incorporeal hereditament, and all falls within the titles of possession only. So everybody that's in that incorporeal hereditament jurisdiction only have a use for a fee, right? And same with corporeal, right? But the corporeal hereditament is the one that's holding the right of ownership in trust for you, right, to the lands, right? So when we go a little bit farther into this jurisdiction thing now, so we can see that we're actually removing these agreements. So we're actually we're changing our own jurisdiction in law, right? So now that you're divorced, your claim is now that you don't have an address, right? The best you could do is get a non-resident post office box for them to be able to send things to you by mail, right? Because you are divorced, you are out of ownership and possession and the fee of your lands, right? And that's because this person in fee simple is holding them, right? So that's why it's where do you live and what do you do for a living, right? Well, you're seized of your lands and everything else, right? And you're there for the warranty, right? And then you start discussing about the capacities of the other people, right? So then that's when where you have to just tell them, right, that the government is a part of the incorporeal hereditament, right? And they only have a use for a fee, and they are the fulfillers, right? And and then you deal with the tenant holding the land. Well, they're in fee simple, right? And they're bound by the warranty, and they're actually in fee simple, so they only have a use for a fee also. And this was the only reason why they have possession of these lands in abeyance is because the government, the fulfillers, gave them a title by purchase, which has annexed your right in law, right, to have it removed, right? So that's why that very first section of your claim it's dealing with who all are part of this, everybody that's a part of this claim and their capacity in it. And you can also add the judge, because the Queen's Bench judge is acting as the Queen themselves. So I would also put in the judge, because now the judge is acting as the trustee. So he's actually should be joined as well, but he can't be, right? You see what I'm getting at? But you need to, I would state it in there that he actually is part of this too, because he's in a certain capacity to make sure that this stuff doesn't happen. Right? And then the rest of it is just a basic summary. So we can see that your claim should be all of 2 pages, 3 tops, because it's very, very simple, right? The government does not have the right to tell you that you can't claim these lands, and the fee simple can't tell you that they don't have the right to give them up, right? So that summary, right? And this is where you guys where if you guys act, because I suck with writing so terribly, because the more that this can be simplified and sucked down to be the most powerful words with the least amount of words for every part of that, means that they have to accept everything that you're saying, and when they deny it, that's what the next part is for your motions. So when you put in a claim, there's no court date attached to this claim. This claim is only the start of the process, and that's why there's just a basic summary to it. And the reason why the opposing party has to reply within a certain amount of days is because of what's in that summary. As soon as you file the claim, you have a bunch of different writs and processes that are immediately available to you. Some writs and motions are not available until after you get that first reply. Once you've gotten that first reply, almost every other motion and writ is available to you.
Hey, I'm I'm a little confused here for a second. You said when you first file that claim, you're talking about a claim that you make after get your release and confirmation.
No, they're not going to send you a confirmation.
They're not going to send you. Okay.
And why are you going to waste money going to court for something that's moot when you can take them to court for the lands and deal with it all at once? Right. And that's basically what Blackstone is getting at in was it chapter 10 in book 4, right? About the actual injuries and stuff. It's because it's a moot point. These are your vested rights. So they don't have a choice because you're vested. They're annexed in law, right? And we don't need to go back into what law is, right? And right, so we can make them lawless and ignorant of the law very fast now, and they're going to prove it if we write a proper claim where they actually deny, because that, or it'd be better if they actually agreed, because if I'm just going to move on because it'll be easier if I just move on. So you do you file your claim, then you get a response back. If they agreed to everything in that claim, now you can file a motion for a summary judgment. Right? Now that motion is where you file with motions can be done in two ways. They can be done using an affidavit or by the actual claim form, right? The form for that motion. Now, the interesting thing is that all motions can be started by an affidavit. Now, if we look into the law of reversion, what is 6.and chapter 18? It is the affidavit. So that's what you're basing your affidavit on. 6.and chapter 18, because that's what vests your corporate person, right? And removes that jurisdiction. So you're making because they didn't give you that deed of release, and because of their ignorance, they're going to deny a bunch of it, right? But if they don't, then you can just file for a summary judgment and put all your evidence in that affidavit, and the judge determines, right? Then you go. I need to fix that. You make a motion for a summary judgment with everything in that affidavit. That makes a court date. So then your opposing party has a chance to get that motion for summary judgment thrown out for what's in your affidavit and in your motion. If you can justify that motion, the judge is going to do a summary judgment on your motion. Right? So if they agreed to everything and then you proved all your law is justifiable and true, you're done. Right? The problem comes in because the opposing party has the exact same rights as you in the administration of law. So as soon as you make that claim, the same motions that are available to you are available to them. Right? Once they've filed the reply, the same motions that are available to you are available to them. So this is why it's when you guys are reading the law of equity stuff for administration of law, I think you would have heard the term flurry of motions. That's what this is about. Because you got it until all the motions are dealt with from both sides, right? From all the parties dealing with that are named on that claim. You cannot move it to trial, right? And there's three types of trial. There's a default judgment, there's a summary trial, and then there's an actual trial that's actually a trial, right? We don't want to be in any of the trials. There's no need for it. You will notice that because these are all done by deed polls and they've signed the deed poll and the indentures are in your name, even for the corporate person, you'll notice the birth certificate, the one that they sent you in the mail, right? The one that nobody signed but the government. That's your indenture for your corporate shares. You don't need it because they've got record of it. You could have sent that back to them and everything else. It's still there sitting there waiting for you. Right? So all this stuff that everybody sends them, government, all this stuff back, don't even bother because it's not doing